Those who investigate must also be investigated. Hi everyone, welcome back. In today's video, we are discussing a new landmark Supreme Court of India judgment from September 2025 involving allegations against CBI officers, the case of Vijay Aggarwal and Sheesh Ram Saini versus Neeraj Kumar and Vinod Kumar Pandey. We'll walk through the background, earlier court decisions, what the Supreme Court held, and its wider importance. Background of the case. In 2000, Vinod Kumar Pandey and Neeraj Kumar, both then on deputation to the Central Bureau of Investigation, CBI, are alleged by businesspersons Vijay Kumar Aggarwal and Sheesh Ram Saini to have committed various wrongful acts. Sheesh Ram Saini's allegations: fabrication of documents, irregularities in seizure of documents seized on 26 April 2000, but the seizure memo was made only next day, 27 April, contrary to procedure manual. Vijay Aggarwal's allegations: intimidation, coercion including use of vulgar threatening language, being summoned by officers despite a bail order in his favor, pressure to get his brother to withdraw a complaint against Neeraj Kumar. Aggarwal's brother is Ashok Kumar Aggarwal, earlier Enforcement Directorate officer, which figures in some of the context. Earlier court decisions. Initial complaints. Sheesh Ram Saini filed a complaint on 5 July 2001 to PS Lodhi Colony, Delhi. Aggarwal filed his complaint on 23 February 2004 addressed to the Commissioner of Police. Preliminary inquiry by CBI. On 26 April 2005, a preliminary inquiry by the Joint Director of the CBI was conducted. That report, at least in part, held that there is material to show prima facie cognizable offences were made out. But the officers, Pandey and Kumar, argued that no offence is made out in that report. Delhi High Court, single judge, on 26 June 2006. The single judge partly allowed the writ petitions by Saini and Aggarwal, directed the Delhi police to register first information reports, based on their complaints, directed that investigation be done by the Delhi Police Special Cell by an officer of rank at least Assistant Commissioner of Police, ACP, and that the findings of the CBI preliminary report be excluded for the moment from being determinative. Division Bench Letters Patent Appeals, LPA. Pandey and Kumar challenged the 2006 order. In 2019, a division bench of the Delhi High Court dismissed their appeals, LPAs, on the ground of maintainability. In other words, they said LPAs were not maintainable. Appeal to Supreme Court. After the 2019 decision, the officers, Vinod Kumar Pandey and Neeraj Kumar, filed special leave petitions, SLPs, to the Supreme Court to challenge both the single judge's 2006 order and the division bench's 2019 dismissal. These appeals were heard by the Supreme Court in September 2025. Parties of the suit. Complainants, respondents in appeals. Sheesh Ram Saini, Vijay Kumar Aggarwal. Accused appellants. Vinod Kumar Pandey, then Inspector on deputation to CBI. Neeraj Kumar, then Joint Director, CBI, later Delhi Police Commissioner. Other relevant parties, CBI as agency, Delhi Police, the investigating officer. Case number, bench, date of judgment. Supreme Court case number. Civil Appeal No of 2025, arising out of SLP, C, number 7900 of 2019 and S.L.P. C, number 7897 of 2019, D number 10495 of 2019 and D number 10508 of 2019. Citation, 2025 INSC 1095. Bench, Justices Pankaj, Mithal and Prasanna B. Varale. Date of judgment, 10th September 2025. Court hearing arguments of both sides. Arguments by appellants, Pandey and Neeraj Kumar. They argued that the complaints do not disclose a cognizable offence under IPC, so direction to register FIR was unwarranted. That the procedure prescribed by law, including dealing with preliminary inquiry report, was not followed before approaching the High Court. They also argued that Section 197 CrPC, sanction required for prosecution of public servants, applies, since acts were done in discharge of official duties. That the report of the CBI preliminary inquiry had found no offence made out, so that should have been a conclusive influential finding. Arguments by respondents, Aggarwal and Saini, supported by ASG in Supreme Court that the allegations are serious and prima facie cognizable offences are disclosed, hence registration of FIR is mandatory under Section 154 CrPC, notwithstanding public servant status. That preliminary inquiry cannot be used to block an FIR when complaints disclose cognizable offences. The CBI's report was preliminary. High Court was correct to hold that the correctness or truth of allegations need not be tested at that stage. That delay arguments and procedural technicalities, tenability of LPAs, should not prevent justice, also the rights of complainants under constitutional remedies. Supreme Court's observations and main findings remarks. The court observed that even investigating officers' agencies are not above the law. Public faith in system demands that those who investigate must also be subject to investigation if there is prima facie cause. The Supreme Court held that the single judge's 2006 decision was correct in law, and that the High Court had properly found that prima facie cognizable offences were made out from the complaints. The court rejected the idea that the CBI preliminary inquiry report, which found no offence made out, could be treated as conclusive and prevent FIR registration. It said that preliminary inquiry at best is an input, but it cannot block constitutional courts, high courts from passing orders if the complaint discloses cognizable offence. As to Section 197 CrPC public servant immunity arguments, the court found that the complaint alleges acts that are beyond mere duty, involving abuse, coercion, etc., and thus sanction requirements, etc., cannot be used as a shield in this context. Though whether sanction immunity might apply in further proceedings could still be tested. On delay maintainability. Though there was a delay in approaching the Supreme Court, after 2006 and 2019, the court condoned the delay because there was no willful or mala fide default. The appellants had pursued High Court LPAs, etc. On investigation process. The court directed the FIR be registered, investigation to be done by Delhi Police by an officer of rank not below Assistant Commissioner of Police. The accused officers, Pandey and Kumar, are directed to cooperate, appear when called, but no coercive steps, like arrest, until investigating officer is satisfied that custodial interrogation is required. Also, the court reaffirmed the legal principle, drawing from prior judgments, that when information discloses a cognizable offence, police must register FIR under Section 154 CrPC. Genuineness or credibility of the complaint is not to be gone into at that stage. Ingredients of the judgment: legal principles established or reinforced. These are key legal principles and ingredients. 1. Prima facie cognizable offence threshold. What kinds of allegations suffice to require FIR registration, even if not fully proved yet? 2. Duty to register FIR under Section 154 CrPC when complaint discloses cognizable offence, not delayed or blocked merely because the accused is an investigating officer. 3. Role weight of preliminary inquiry reports. These are not decisive. They cannot be allowed to foreclose FIR or investigation if complaint discloses cognizable offence. 4. Public servant immunity. Section 197 CrPC. Not an automatic shield when allegations are serious beyond scope of mere duty. 5. Constitutional remedies. High Court's power under Article 226 writ inherent jurisdiction to direct FIR registration when police do nothing. 6. Justice must not only be done, but must also be seen to be done. The importance of the appearance of accountability. 7. Protections during investigation. Accused officers get rights to participate, to challenge, etc., but cooperation required, non-coercive steps unless IO satisfied otherwise. 8. Condonation of delay maintainability technicalities. Courts can condone delays if there is no mala fide or deliberate inaction. Other notable matters. Additional observations. The court changed one detail. Though High Court had asked Special Cell of Delhi Police to investigate, Supreme Court directed that Delhi Police itself do so, but ensuring rank officer not below the rank of Assistant Commissioner of Police. The court stressed expeditious disposal, since matter is very old. The judgment is reportable. Importance implications. The ruling is significant for accountability of public servants, especially investigating officers. It sends message that even those whose jobs are to enforce the law can be held accountable under law. It may affect how preliminary inquiries are treated in future, cautious over relying on internal investigative agency reports to block FIRs. It reaffirms access to constitutional writ remedies when police refuse or delay to register FIRs, may lead to more FIRs in older cases or cases where senior officers are involved, for serious allegations. Also emphasizes procedural fairness and institutional transparency, proper Caesar memo, following manuals, etc. Conclusion. Summing up, the Supreme Court in this case has upheld the Delhi High Court's order to register FIRs, rejected attempts to use preliminary inquiry as a shield, and laid down that investigating officers are not immune when allegations of serious wrongdoing are made out. Justice delayed is justice denied. Many years passed, but the court has insisted that even now the matter must be investigated. If you are following legal developments, this is a case to watch, especially for how investigations proceed, whether any sanction challenge arises, and how the evidentiary trials move forward. If you liked this video, please like, subscribe, hit bell icon so you don't miss similar legal updates. What do you think? Should investigating officers have more protection, or should principles of accountability override that? Leave your comments below. Thanks for watching. See you next time.